fine. Like, for example, if I were crossing a line, I'm almost certain to get my name, but I also enjoy wine.
You know, there was a tremendous amount of tension in the room just before you announced the sentence. There was a pool going on. People were picking a number of years, and everybody had a different number. Was anybody here surprised at the sentence?
No, I thought the sentence was within the range that would have been reasonable. Mm-hmm. It's not as if you could argue it should have been 11 years instead of 12. Yeah. But it was within the range. I might have gone a little lower than that, but I can imagine reasonable people going a little higher than that. So I thought it was a very reasonable sentence.
My granddaughter came over to me to get me into the pool, and I said, and I thought, well, I think it's about 10, and she said 4. Or 6, I don't know, and I thought, oh, maybe she's right, and so I changed it. I made it 5, but I thought 10. What were you thinking?
Well, I was glad that the state makes these decisions because, of course, if that had been a family member, send them up the river forever, you know. So you really appreciate the fact that it's a good thing a third party tries to adjudicate and decide what justice is in this kind of situation. So the notion of 12 is a lot for a young man, and it is true. It allows to build his life after that. It's not a hopeless sentence. So in practice, does 12 mean parole at 6?
Well, of course, in this program, we didn't specify the jurisdiction, and we tried to make it fit so it could be any state or even the federal government, but it varies tremendously from state to state. In some states, there's an initial parole hearing after 1/3 and a second parole hearing after 2/3, and it's a multi-factor test. In some states, as you pointed out, there's a hearing after 1/2 of the sentence. There's no state that I'm aware of where he couldn't get at least some reduction based in part on how he does in prison.
What's the maximum that he could have gotten for
50 years.
50 years?
Were you surprised at all at the sentence?
I thought it was lenient, honestly.
Really?
I did. I mean, not given that he's a juvenile, I think, and a first-time offender. It is a sentence that still seems like a serious number of years in prison, but given that you have somebody in a vegetative state at this point, and there was very thin evidence to try to undercut his role as being the shooter and his role in planning and actually bringing the gun to the spot, you know, I thought that he easily could have been given 20 years, and that it, you know, given the way that the evidence was presented, that might have actually been the case. So when you described that this might actually be a sentence that was lenient compared to what other judges might assign, I agreed with that. I thought it was actually a generous sentence. It follows the trend we see in a number of jurisdictions where, particularly with respect to juveniles, the sentences are starting to take into account their age and really recognize that they shouldn't be written off, that there actually is a good possibility that they can change and that they will actually be able to become reintegrated in society, and also recognizes that prison may not be the best way to do that. And so, you know, in that way, I think it follows a growing trend, but it's certainly on the lower end of what he could have been given.
And it's thoughtful, too, because if he stays there 12 years, then his white matter should be pretty much myelinated by then.
That's true.
And that, of course, is how I decided.
Yeah.
But, you know, it's interesting because when you say that his, you know, his white matter could be myelinated by then, the impact of being in prison while his brain is developing really actually means that he may have a much harder time becoming somebody who is truly integrated, because, you know, prison is an environment that's really a deprived environment for growth and development. And so the type of growth and development that you would see with a juvenile is going to be quite stunted in incarceration than it would be in general society.
Judge Rakoff, it seems to me that following along those lines, since you have made it a practice to keep up with the advances in neuroscience, does it jar you at all when you put someone in prison knowing that it's an environment that is not really going to be beneficial to their brain development?
It's been known for a long time, even before we got to the neuroscience evidence that people come out of prison worse than they went in many, many instances. We have not developed, however, frankly, a good alternative. For example, it's very easy for a judge in a narcotics case, when you're dealing with a low-level person who is an addict who committed his crime because, at least in part because of the economic pressures of feeding his addiction, to say, oh, we won't send that person to jail, we'll send him to addiction treatment. But in fact, most addiction treatments don't work. Their success rate is very low. So that person goes into the treatment, he's with a lot of other addicts, he gets re-addicted, and he comes out and commits a new crime. So this is, one of these Hobson's choices, so to speak, a dilemma that is not easily resolved because we don't have the tools to provide a good alternative to prison in many, many instances. Now, there have been, for younger juveniles than he was, there have been some more hopeful steps towards developing programs, not for addicted juveniles, just for, if you will, juveniles who are having trouble managing their impulsivity, who come from difficult backgrounds and so forth, and their education and training and so forth, it is believed, can make a significant difference. But the question you always have to ask yourself when you say, will sending him to prison make him worse, so to speak? And the answer to that is yes, but then you have to say, well, what's the alternative compared to what? And if you don't have a good alternative, then it may be truly a difficult dilemma.
With regard to that, I think one very nice aspect of the sentence was that it was 12 years followed by 5 years of probation, and that you specified medium security rather than going for a higher level of security. And there have been studies that show that people who are put in higher levels of security, come out more likely to recidivate than if they were in lower levels of security. On average, of course, it varies a lot from case to case. But even picking the security level within the prison can affect the way they're treated and what kind of effect that has on the rest of their life. And certainly probation, in this case, I think, I might even have said 10 years of probation, because this seemed like a person who needed some supervision once they came out, needed somebody to make sure they weren't going back to their old ways.
But if you think about it, when he comes out, he'll be 30 years old. And so, most of the studies show that the rate of recidivism drops significantly after, really 35. But from 25 years old in males, there's a decreasing activity for recidivism.
That was actually part of what was in my mind, is to get him to an age where he would be more mature when he came out.
And maybe jobs available then too, so there's all kinds of benefits. But speaking on the neuroscience brain development part of it, I would like to urge caution. We've known that the brain gradually develops and myelinates for a long time. But what we also know from developmental psychology is that concepts such as retribution, concepts such as fairness, concepts such as reciprocity, they're in the 12-month-old baby. They're all there. And we come with that hardware, so to speak. And so to think that someone makes a misjudgment at the age of 16, 17, or 20 due to a slowly myelinating brain argues it's contrary to the facts that we know those relationships are understood very early by the human. So I think we have to be careful about what the brain development correlations are with antisocial behavior.
In law, we care about actions. We care about actions that people take. So in this case, we care that Jimmy brought a gun to a convenience store, and that he took the gun and he pointed it at a person, and he pulled the trigger of that gun. And we care about preferences and desires that he has as well. So for example, if I really like chocolate cake, and I also don't want to gain the weight from chocolate cake, or I know that chocolate triggers migraines for me. I have preferences and desires that are competing, which is a preference for chocolate cake, a preference to avoid gaining weight, a preference to avoid getting a migraine, and I can take those competing preferences and make an action choice, which is to either eat the chocolate cake or not eat the chocolate cake. And here with Jimmy, he had preferences and desires. He had influences, including being young, including having gang members, including having a difficult childhood, including having many different challenges that he faced. But he made an action choice. His action choice was getting a gun, bringing it, and pulling the trigger. And that's what we care about.
Okay, but here's what makes this complicated. We're dealing, it seems to me, in a legal setting where we must hold people responsible for their actions. However, the example you gave is such a wonderful everyday example of trying to act as though your decisions will be made consciously and that they'll be made in your best interest, that you follow through on them. When you choose to take an action which leads to the migraine or the weight gain, you would, in many cases, rather have not done that. But somehow you very often take the wrong choice. Now, you're not going to get put in jail for it, but you'll suffer for it. But it's not always both conscious and in your best interest, and how you would behave on paper if you wrote it out and said, this, of course, is the choice I'd make.
Well, but that's to say they were
And
competing.
so what the real issue then is control. Are you controlling the things that happen or not controlling
Yeah,
the things
which
that
is maybe a better substitute for free
free
will.
Exactly.
Yeah.
So did Jimmy have control? Now, a lot of the facts weren't clear, and I'm not sure exactly what was going on in Jimmy's case from the testimony and the videotape. But suppose he walked into the store saying, I want to have this gun, and I want to have it loaded, but I really don't want to use it. My preference is not to use it. And then the shop owner's wife comes, and he gets startled and points the gun out of a natural reaction and pulls the trigger, and then thinks, oh my God, what have I done? It could then
It's
be
a hell of a time to say, what have I done?
But he,
no,
chose
of course,
to
of course.
bring-
But the point is
Right, but Walter,
that
back up, he chose
would
to
not
bring the
have.
gun.
The point is that it could have happened so quickly
Yeah.
that he was not able to control whether or not he shot her in the situation.
But
But
why
there's
did he
a-
bring a
Right,
loaded
but
gun?
I mean, he
He
had
brought a loaded
control
gun
over
to
whether or
thro-
not to bring the gun with
Yeah,
him, and
yeah.
whether or not to choose to take it
Well,
with him,
but I-
But then
and choose
he's
to
guilty.
take it out.
But then what he's guilty of is bringing the loaded gun with him. Armed robbery, absolutely.
Well,
There's no
and the
question.
recklessness and the reckless situation that he created, the natural and probable consequence of which was that he would end up shooting somebody, and somebody would suffer grave bodily injury as a result.
Judge
I
Rakoff.
think while you've accurately described the current way the law looks at it, that it's somewhat simplistic and somewhat in contradiction of what we already know from not only from neuroscience but just from common experience. And I'm not talking about the chocolate cake, because there I would choose the chocolate cake every time. But
that gun was maybe his chocolate cake.
That's it. But there's a famous case about 10 years ago where a guy for the first 41 years of his life was a perfectly responsible, respectable citizen, and then he began developing an interest in child pornography. He knew it was wrong, but he also made what, at least to him, appeared to be the conscious choice to nevertheless look at more and more child pornography. And finally, he went further and made some inappropriate suggestions to his stepdaughter. At that point, the mother called the police. He was arrested. He pled guilty because he said, I knew what I was doing was wrong, and I did this as a conscious act. The judge, perplexed by the fact that he had been so responsible up until about a year before, said, I'm going to hold off imposing sentence. We'll send you off to a program that'll help you overcome these urges, and then we'll sentence you if you successfully pass the program. He went to the program and he flunked completely. He got worse, and no matter what the efforts were. And he was about to be sentenced, and the night before sentence, he developed these huge headaches. They took him off to the hospital, they did a brain scan, and they found a tumor that was impinging on part of the brain. They took out the tumor, mostly for health reasons, but as soon as they took it out, he went back to being a perfectly responsible, respectable citizen. The judge said, I'm still going to hold off sentence for a while, see if this is for real. And for another 4 or 5 months, he was a perfectly respectable citizen. Then he began, once again, getting an interest in child pornography. This time they took him directly to the hospital. Another brain scan, they found that the tumor had grown back. They hadn't gotten all of it the first time. They did a second operation. This time they got all the tumor, and he was fine, and the judge did not sentence him to jail. Now, I think this raises all sorts of difficult questions. For example, supposing the tumor had been inoperable the second time. Now you know from the first operation that's probably the tumor that's really causing the behavior, although he regards it as conscious behavior, albeit behavior that he doesn't like. But you can't take out the tumor in my hypothetical. Do you send him away to jail for life because sooner or later you think he's going to molest some child? Do you do nothing because he's not, quote, responsible in the eye of the law? So I think the law has a lot of catching up to do, is my point in this area.
I have two problems with that case because I've
Only two?
well, at
I
least
thought you were
two.
a law professor.
I have at least two problems with this case. So one is there are a number of people who have exactly the same type of tumor, who do not actually become interested in child pornography, and and have no impulse that is developed from it. So the idea that the tumor caused his behavior is purely speculative in my mind. But second is the idea that that caused action is also something for which there is no proof. It may have influenced his behavior in the same way that my desire for chocolate cake is influenced by genetic predispositions to things like liking chocolate and having, supposedly I have a genetic predisposition to wanting more sugar than most people. So maybe it acted as an influence, but there are many things that act as influences on our behavior, whether it's our environment, our genes, our brains, what we had for breakfast, what kind of schooling we had, whether our parents read to us. And so why would we privilege this tumor above all of those other factors in law and think that it somehow has special purchase on his behavior in a way that those other things don't?
Could I ask, I'd like to know what other people think about this, because these are the right people to ask. It seems to me the chocolate cake analogy is a really interesting one, because it seems to me to point to the complexity of this problem. I certainly would not argue that people should not be punished for wrongdoing. I think they should. But there is the question of what's going on under the surface, and the chocolate cake is perhaps an example. The presence of too little or too much ghrelin in the system can make something in you say to you, I gotta have that chocolate cake or I'll die of starvation. And that's at a certain point that when you give in to the impulse, even if it's been sitting there for a long time and you've successfully resisted it, if you finally give in a way, it does that or does that not reduce some of your decision making to a level that you're not in control of?
I think I love the way you put it, because it shouldn't be a question of, is the person in control or not? Is the person responsible or not? Is the person free or not? It should be, does it reduce your control? Does it reduce your responsibility? I think it's a big problem for the legal system, because you have to find him guilty or not guilty of the crime, and yet neuroscience is showing us that there are all kinds of degrees and dimensions and complexities that make it very difficult to put a person in one box or another. It's like you've got a post office with 2 letter boxes, and it's got to either go to this person or that person.
But the problem with the legal system, as I see it, is it tries to cram all those issues into whether the guy's guilty or not.
Yeah.
I think the whole system could be cleared up a lot by saying, look, let's decide whether Jones is the agent of the crime. You do it. Take 5 minutes, half these cases, right? Mm-hmm. Now you're moving into the mitigation, the sentencing, the tough stuff. What does society want to do with them? That's going to be built on a lot of social thinking that is changing in our society. That's where the action is. That's where neuroscience is going to really have its big hold in the future. It's going to start coming up with ideas for treatment for people who are engaged in antisocial behavior. And just imagine this. So somebody engages in a terrible thing like in this trial, but in fact, let's imagine that neuroscientists figured out how to treat that person. Put him on the street. He's going to be fine. He needed this little pharmacologic agent. Then society has to be ready to do that. We're not ready to do that.
Are we ready even to come up with the solution?
No.
I mean, that might be 15
But it will
years away.
occur. I mean, what neuroscience is dangling in front of us is the fact that it's taking people with various antisocial traits, figuring out what's possibly wrong with their brain. Then once you figure that out, say, well, how could we fix that? And you can see the progression down to medication. And that's the big sweep of this. And that's why it's so important to have neuroscientists and neuroscience be looked at now, because it's all coming. It's not there in a lot of places now where it's talked about. It's there, in my opinion. But it's all coming, and the real decisions will come to society. Do we want to accept these solutions? Because of this feeling, this retributive feeling, they killed my relative. Those are strong feelings, and we're not going to get rid of those. I mean, I'm going to have to take the pill, to accept it. I mean, you would think. So that's, seemed to me, this is the framework, this is the structure that we're building towards, and these are the issues that are going to really come down the pike in the next 15, 20, 50 years.
Before we come out with those ameliorative procedures, are we in danger of bringing into the court diagnostic procedures that are premature?
Yes.
What are they, and what's the danger?
Well, I think you're examining many of them in the show, but there is no question there's going to be sophisticated developments that will, to take the hot potato one, the hot issue on lying, there's no question that the field is going to get better and better at detecting actual lying. It's not there now. It's not usable now, in my opinion. Some people think it is, I don't. You're going to be able to get technologies to detect abnormalities, to detect mental states that are of importance and of interest to the court. That's all coming. It's not there yet, but it's coming. And the thinking about it is so important to get straight that we got to start thinking about it now. And that's why I think this is such an important topic.
But what about something we talk about in the introduction to the show? Are you entitled to your own thoughts? Or is that an invasion of your privacy? You're not supposed to give testimony against yourself, and yet, if they can get your brain to give testimony against you, isn't that the same thing?
Well, I think it raises important constitutional questions that I think would be difficult to work out. For example, you can, under the Constitution, force someone to give a blood sample for a blood analysis in a criminal case where there's a blood sample found at the scene of the crime, and you can be forced to give it, and that's been held repeatedly not to offend the Constitution. Getting into your thoughts is something a little bit much closer to what the Constitution, I think, had in mind when they enacted the Fifth Amendment. I think there's a caution that needs to be exercised before we allow neuroscience evidence in, for example, the brain scan kind of situation. There's a long history of the legal system buying in too early to scientific advances and regretting it afterwards. In the 1920s, there was a science called eugenics, and it was very well accepted in certain quarters. The Supreme Court of the United States approved the forced sterilization of women because the theory was that you inherited immediately and exactly certain traits of imbecility from generation to generation. No less a liberal than Oliver Wendell Holmes wrote the decision in that case, and he thought it was good science, and then it turned out to be bad science. And in the 1940s and 50s, there was a lot of belief that lobotomies would solve a lot of depression in people. And while most of those were not forced, it was very common. Sister of President Kennedy is a famous example of that. And then later on, the science developed, and they no longer thought it was such a good thing. It left people as vegetables. So caution here, I think, is very well called for.
So I want to tie that in with a question you asked earlier about diagnosis versus treatment. So I think, you know, these are good examples of how the legal system has often had science introduced well before it's really ready for prime time. And we're seeing that already, particularly on the diagnosis versus treatment side for neuroscience. So in a number of criminal cases over the past 5 years, there's been neuropsychological testing that has been introduced into the criminal case. And so this is a neuropsychiatrist who does a diagnosis of a person and says this person has organic brain disorder, or they have a tumor, or they have frontal lobe damage, something which makes them more impulsive than most, or makes them less likely to have had full control over their actions. And in the beginning, it seemed like this evidence, even though it's really quite new, and to Mike's point, we don't really know what it tells us about behavior, it seemed like this was going to be powerful evidence for a defendant because it suggested that they weren't fully responsible for their actions. But very quickly, we've seen prosecutors seize that evidence and use it as a double edge against a criminal defendant because there's no treatment that's available yet. So what they say is, what you've demonstrated is that this is a defendant who is unable to control their impulses, who is more likely to act in a wrongful manner than the next person, and that they're incorrigible. There's no way to fix them because there is no treatment that's available. For many of the new techniques and new discoveries in neuroscience, the diagnosis precedes the treatment by years. And so now we see criminal defense attorneys choosing not to introduce the evidence, making a strategic choice to, after they receive the diagnosis, to keep that evidence out of the courtroom because the prosecutor can't then independently raise the evidence. And they don't want to open the door for questions that we saw in this case, like what is Jimmy's future dangerousness? So when the psychiatrist was making a prediction of his future dangerousness, if the defense attorney chooses to never open the door by introducing any of the neuropsychological testing, they can try to keep that evidence out of the case. And so, especially when the science isn't ready for prime time and the only thing that we have is diagnosis and not treatment, it really can be something quite damaging to a criminal defendant and maybe better held back until we actually have further developments in the field.
A point that Mike made earlier, which I think is worth reiterating, our rules of evidence and the nature of the decision that has to be made at the guilt phase is very narrow, very strict.
Right.
The nature of the evidence permitted and the nature of the kinds of decisions that have to be made at the sentencing stage are much looser, much more flexible. It's hard to understand why one should be so extreme and one should be so fluid, so to speak. But that's the way it's developed, so that a lot of neuroscience evidence that would not come into the guilt phase at all under present standards could easily come in at the sentencing stage under present standards.
The other relevant comparison is between neuroscientific evidence and non-neuroscientific evidence. You know, there are a lot of flaws in neuroscientific evidence, sure, but there's a lot of flaws in a lot of the evidence, in eyewitness testimony, in fingerprints that are smudged along the walls of the crime scene. All of this evidence has tremendous flaws, and yet it's allowed in. And so there's a question of why neuroscientific evidence, if it's relevant and even minimally probative, shouldn't be allowed in.
Well, the great thing about neuroscience and why I'm so optimistic about it in the long run is it's being developed by the scientists. The science that has most come into the courtroom of that sort is DNA evidence, and that is really good in 99% of the cases. The stuff that you're talking about, which is fingerprints, ballistic tests, handwriting samples, and so forth, was largely developed by non-science scientists, and it's only recently that it's begun to be subject to scientific scrutiny. A lot of that scrutiny has exposed flaws in it, which are very slowly creeping into the legal system. The judges are by nature old fogies, and so
You said it, not me.
Well, I mean, I speak from experience, and so it takes a while for this stuff to filter down. But I think the real distinction is between something being developed by scientists and something that's not. Where it's developed by scientists, I think the scientific controls will eventually make it good. I very much agree with everyone that neuroscience isn't there now.
As do I.
Yeah.
You know, it was interesting to hear you deliver your verdict, because as you were talking, it seemed like, just as you were saying earlier, there's a lot of flexibility in sentencing, and yet there's very little option or range of options for you to develop as sentencing alternatives. So you were taking into account quite a number of issues that were raised during the case, issues which seemed to impact the way in which you wanted to sentence Jimmy here. And you were expressing, it seemed like, frustration with what your options were for how you could take into account that he wasn't somebody who was incorrigible, that there was hope that he would change in the future, that there was evidence that he might be able to change his behavior once he's able to overcome his addiction. And so I was wondering if you could talk a little bit about your, maybe my perception of
your perception is correct.
Of your frustration and what it is, you know, that you would like to see happen as alternatives and how neuroscience might help that.
So you correctly perceive some of the frustrations I feel, but I think regretfully it's a little more negative than even you're suggesting, because even if the money were available for other alternatives to prison, which it is not, right, even if the public was accepting of alternatives to prison, which it largely is not, there's a dearth of evidence suggesting that the alternatives really work. So the real dilemma a judge faces is this. You know that in many cases, an extended jail time is not going to be the most protective of the public of the options you would like to have available. Because surely that's one of the most important things any judge has to take account. If you knew that you were turning a troubled teenager into a mass murderer by sending him to prison, you wouldn't send him to prison. It's never like that, but just to give a hypothetical. But if you don't have any program that is a meaningful treatment for him, if the statistics are that the people who go into these various programs, for the most common one being drug treatment programs, but there are also mental health programs and so forth, tend to become recidivists, then you are really in a very pessimistic situation because you don't have good alternatives. So you feel the frustration doubly, if you will. I also think we have to take account of the fact that it's not just a question of the defendant that's surely an important, very important question. But there is a deep-seated, and I suspect maybe you guys can tell me, but hardwired desire for retribution. And we can't ignore that. That's part of the human condition too.
So I wonder if the sense of retribution that you're describing from a societal perspective would be different in the case that you described. For example, if the public understood that the person's behavior was closely connected potentially to a brain tumor, and that their behavior changed dramatically once the brain tumor was removed. Or there are similar examples where criminal defendants who often come from poor socioeconomic backgrounds and haven't had access to mental health care during their lifetime go through different diagnostic procedures after they've committed a crime, and you discover, for example, that they have low dopamine levels, or they have low serotonin levels, and something as simple as an SSRI, an antidepressant, changes their behavior dramatically so that they no longer act impulsively or explosively or aggressively. I wonder if that would lessen the kind of deep-seated sense of retributivism that we see in society.
Well, I was just going to say that I think that point is abundantly clear from every perspective. Evolutionarily, it's the case. Neuroscientifically, there's all kinds of sorts of evidence to support it. And the question people ask is, can we culturally rise above it and frame the future differently? The question that I think this speaks to is, can we imagine a time when, once the legal system gets done with identifying the defendant as the agent of the crime, why is it the legal system that decides what to do with them? Why isn't that given over to a group of professionals who deal with the maintaining human capital, basically, or however you want to phrase it?
I think your point is well taken, but I think you're ignoring another factor, which is the evil influence of money.
Well, there's always that.
Because what has happened in many court systems, where while the decision is made by the judge, the decision is often to send them to this program or that program or whatever. Those programs are for-profit programs. They make billions of dollars collectively a year, and many of them have never been put to the test of how good they are, what their track record is. They talk the talk, and they are experts for sure at grant writing and application to the federal government to get money. That's their area of expertise.
So why are there so many people in jail in this country?
Well, this goes back to the point that was being made. I don't think it's only a question of hardwired retribution. I think cultural factors play a big role. We have historically been a punitive society, a moralistic, perhaps overly moralistic society. I mean, you can have debates about this, but there's no question that there's a huge satisfaction that the American public feels when the bad guy goes to jail and the good guy, the marshal, goes back to town and has cleaned it up.
We have too many movies.
Well, you said it. I mean, no, but it runs very deep in American culture. I'm not enough of a historian to tell you all the reasons for it. I think the acknowledged role of religion in American history is perhaps part of it. But there's no doubt Americans feel good when bad guys go to jail, and that's not wholly irrational. But there it is.
It seems like something that may be changing, though, is what our definition of a bad guy is, right? So, for example, I mean, totally apart from neuroscience, there is a significant debate in this country over which drug uses or abuses should be subject to criminal sanction. And so a large part of our prison population right now are people who were involved in drug crimes. And as societal perspectives of behavior change, then what you may find is that, you know, what we thought were bad guys before are no longer really the bad guys of today. And so marijuana use is an example, right, where in some jurisdictions they aren't prosecuting it anymore, and a large part of the prison population were those things. I wonder if that will translate from not just things like changing definitions of crime, but also changing sentiments about individuals.
Well, a very good example of that, albeit one that the public is still divided on, is homosexuality. And, but this also, I think, points up my concern about professionals handling it, because the DSM, the manual that psychiatrists and psychologists look to as the definitive manual in diagnosing mental disorders, back in the 50s and 60s, classified homosexuality as a mental disease. And therefore, if you were progressive in that period and someone was a homosexual, you didn't say, that's great, you know, everyone has different lifestyles and all like that. You said, oh no, you've got a mental disease, but I'm not going to send you to jail. That's what they do in bad places. I'm going to be a progressive. I'm going to send you to a psychiatrist who will cure you of your homosexuality. So, you know,
and we have a bad history of that in this country. I mean, so that's one example. You brought up the example earlier of coercive sterilizations that we had. We've done it with, for example, in the 80s and 90s, crack-addicted mothers who had forced Norplant or forced birth control as a sentence that was imposed on them. So one dangerous, you know, kind of alternative is when we start outsourcing questions of justice and medicalize them, that oftentimes we can end up with even worse results than incarcerations.
But I'm really worried that, I mean, certainly you want to learn from history. You want to learn that those mistakes were made and why they were made, and carefully analyze it so that you can avoid making those mistakes in the future. But if we get the attitude that this was messed up at one point in the past and therefore we're not going to do it anymore, we're going to be losing out on a lot of opportunities where science can help us do it right this time, even though admittedly it was done wrong in the past.
But not just one time, many, many times. Right?
Absolutely.
I mean, at each juncture that
Look,
we've had a new
medicine,
scientific theory,
doctors
there's
before the
been
20th
problems.
century probably killed more patients than they helped. They did a lot of damage. That doesn't mean we shouldn't develop medicine.
so I agree with that. But the point is that the legal system should accept it when it has been validated to a significant degree, and not just let it flow in because some company is packaging it nicely.
There we absolutely agree.
Well, and I mean, just to build
No, but-
on that,
but-
if we have the legal system serving as a gatekeeper of this different type of science, as opposed to outsourcing sentencing decisions to some group who has whatever their fashionable science is of the day, using that to make decisions about a person's liberty, I think we're in a better position. And so, you know, judges serving in gatekeeper roles, the legal system serving in a gatekeeping function so that science doesn't enter until it is truly validated, I think is a useful societal function.
Well, I would just say that we're backsliding here a little bit, that into the present. When
Backsliding to the present.
Yeah, we're backsliding to the present because the whole point of this effort here is to show how neuroscience is going to change things out there. And one of the things to think about is the gold standard in the law now, DNA, was only discovered 70 years ago, all in our lifetime, at least in my lifetime, maybe your lifetime.
Oh, yeah.
And look at the fantastic advances in that field. Well, the gold standard in neuroscience is really not there yet, but we're going to develop it, and it's all coming. And all of these questions then come with them about maybe other kinds of professional gatekeepers. I mean, it's not that the justice system doesn't have a lot to do. They might well develop an arm to itself that would help in this area, and gladly so. So I don't see it as a radical solution. I can just see the kinds of issues that will be discussed about 10, 15, 20 years from now will be of such a different kind that there may be the development of a second or ancillary profession. That's all I'm suggesting. But it's coming.
It's coming.